Hadirin yang dimuliakan yang masih berada di luar Dewan, majlis kita akan bermula pada bila-bila masa, jadi dimohon untuk masuk ke dalam Dewan dalam kadar yang segera. Dimohon pada pegawai SUHAKAM yang bertugas untuk menjemput tetamu-tetamu yang masih berada di luar untuk masuk ke dalam Dewan sekarang. Hadirin yang dihormati sekalian, seperti yang tertera dalam agenda majlis, kini kita akan bersama-sama mendengar pengisian sesi panel diskusi yang bertajuk Ending Statelessness in Malaysia, Critical Role of Policy and Law Reform and Way Forward. Barisan panelis yang akan ditampilkan ialah Profesor Emeritus Datuk Dr. Haji Syed Salim Faruqi, Pemegang Kerusi Tunku Abdul Rahman, Fakulti Undang-Undang Universiti Malaya, Puan Jasmine Wong, Senior Associate di Mahweng Kwai and Associates, Profesor Datuk Dr. Nur Aziah Haji Muhammad Awal, Naib Pengerusi Suruhanjaya Hak Asasi Manusia Malaysia SUHAKAM, dan Puan Malini Ramalu, Pengarah Perlindungan Sosial Development of Human Resources in Rural Areas DHRRE. Sesi panel diskusi ini akan dibudacara oleh Tuan Ragunath Kesavan, Pesuruhjaya Suruhanjaya Hak Asasi Manusia Malaysia SUHAKAM. Tanpa melengahkan masa, saya serahkan majlis ini kepada Tuan Moderator. Dengan segala hormatnya, dipersilakan.
Terima kasih saudara pengacara majlis. Thank you ladies and gentlemen for coming to this launch of this book or this report, Human Rights and Statelessness. Very briefly, it's a very important issue. It affects all of us. It's a problem that's plagued the nation for many, many years. This is a wonderful report. It's so thorough, it's complete, it's got so many recommendations. And I think one of the proposals that we have is to translate this report into at least Bahasa Malaysia. Whether we can then do it in other languages, let's look at the budget. We have 4 eminent speakers. I don't want to waste time to introduce them. They're very, very eminent people. They are specialists in their own areas. The first speaker is Professor Emeritus Dr. Shad Salim Faruqi, eminent constitutional expert, a professor to many law students here. And always it's a pleasure to hear him speak. And without any further ado, may I invite Prof to do his small presentation, then we'll have a lively question and answer after this. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Mr. Chairman, Tuan Raghunath, distinguished members of the panel, learned participants, especially Dr. Milati and Nicole, thank you for your very fine report. Now, much that needs to be said has already been spoken, so I can only reiterate a few points, primarily from the constitutional law point of view. May I begin by saying that the push and pull factors that cause statelessness are so varied that nowhere in the world can statelessness be ended, as our topic seems to suggest, ending statelessness. We can only reduce the causes and mitigate the harm to victims. Please do bear in mind that the Constitution and laws are not a solution to all our problems. The law is only one of the many factors and forces that affect society. Regrettably, in matters of citizenship, race, ethnicity, religion, language are the unspoken, inarticulate factors that affect administrative decisions. See, for example, how the UK is reacting to both people at its shores. So the challenges are both visible as well as subterranean. Let me now go to the next slide. Statelessness is not a new phenomena. Some scholars suggest that it began with the citizenship provisions of the Merdeka Constitution, which, though generous in many parts, did not embrace all the immigrant workers during colonial times who had made this country their abode. The problem got worse with the abolition of jus soli in the 60s. Data is not easy reliable data is not easy to get, but it is estimated that there are over 1 million stateless persons in Malaysia, of whom 290,000 are stateless children. Now, the dehumanization of these helpless, invisible, and undocumented categories of fellow humans raises significant issues of constitutional law and international law. The next issue I want to raise is who are the victims of statelessness. The point has been made earlier. I just want to point out that those suffering from xenophobia, and many people do, xenophobia towards stateless people should take note that the victims of statelessness are not security threats. They are often children born out of wedlock whose births were not registered, or children born in this land but who lack birth certs or other documentation due to the poverty or ignorance of their parents or other structural and systemic issues. My kids were born in Asunta Hospital. I went down 2 flights of stairs, registered them. Or what about those who live in the hinterland where there are no roads and no transport? They'll probably postpone it to tomorrow or day after. Sometimes actually they never register their children. Then there is no birth certificate, there is no IC. So I think these are structural, systemic issues. There are many other such categories. May I go to slide number 8? Now, what about international law? Malaysia is reluctant to ratify and incorporate the many international laws on stateless persons, rights of children and women. The problem is that under the Constitution's Article 160, Clause 2, the definition of law does not make any reference to international law. So it is an accepted dogma that international law is not part of our corpus juris unless explicitly incorporated into legislation. With all due respect, it is possible to argue that judges are not prevented from taking note of international standards for the following reasons. Slide number 9, please. First of all, Article 160, Clause 2 of the Federal Constitution defines law with the words, law includes. It doesn't say law means. There's a difference. Common law is part of our law. Thirdly, there are common law rulings in the UK that there is a constitutional presumption that the law of England does not intend to violate Her Majesty's international obligations unless an Act of Parliament explicitly says so. The United Kingdom takes an incorporationist view, holding that customary international law forms part of common law. Another reason I say that judges can take note of international law is that our Civil Law Act imposes cut-off dates. But the Civil Law Act is a pre-Merdeka law. All pre-Merdeka laws are subject to Article 162, Clause 6. So if the Civil Law Act 1956 clashes with the definition of law, which says common law is law, we know which law should prevail. Now I come to constitutional issues. In general, it may be said that though the Constitution has many flaws, there are some helpful provisions that are meant to prevent statelessness. Unfortunately, the authorities are often reluctant to enforce these constitutional safeguards. This means that the problem of statelessness is not entirely legal, but is partly administrative, political, ethnic, and other such problems. There are commendable provisions. I'm on slide 11, under Article 14, Clause 1b, and the second schedule, Part 2, Section 1a. As long as a child is born within Malaysia and has one parent who is either a citizen or permanent resident, the child is entitled to citizenship by a combination of the principles of jus soli and jus sanguinis. Another admirable provision is that the Federal Constitution in Article 26b states explicitly that no person shall be deprived of his citizenship if he would not be a citizen of any other country. In other words, statelessness must be prevented. Slide 13. However, there are some problematic provisions. Number one is a patriarchal one. There is discrimination against a mother if the child is born abroad. Under the second schedule, if a legitimate child is born abroad, We'll come to illegitimacy later on. If a legitimate child is born abroad, the Malaysian mother's citizenship does not matter. The child inherits from the father. Now, this obviously causes problems if the father is a non-citizen. Next one, slide 14. Illegitimate children born locally. Section 17 of Part 3 of the second schedule mandates that any reference to a person's father, parent, or one of his parents should, in the case of illegitimate children, be construed to mean mother. This means that an illegitimate child must take on the citizenship of his or her natural mother, even if born locally and even born to a Malaysian father. I think this discriminatory provision should be amended. It's not just discriminatory, it's entirely inhumane, really. Consanguinity with any one parent should be enough. The law should obliterate the distinction between legitimate and illegitimate kids. It should not victimize children who are the victims of circumstances beyond their control and, of course, before their birth. I know that there are some decisions like Rizwan Muhammad Napoleon 2022, which you commented on, where the child was born in Malaysia and the father was Malaysian, but the mother was non-Malaysian, and the court held the child is entitled to citizenship. That's commendable, but it could have gone the other way by looking at Section 17 of Part 3. So our judges are deeply divided. Some judges look at specific provisions literally and in isolation and say, that's the law, I have to follow it. Other judges look at the law holistically by examining the entire chapter, and along with examining explicit provisions, they make explicit what is implicit in the law in terms of principles, objects, and purposes. Ronald Dworkin, the great Anglo-American philosopher, says, law consists of rules plus non-rule standards. Nobody who has studied equity can deny that law consists of non-rule standards. And not only in equity, in family law, in criminal law, in contract law, there is definitely, beyond the explicit law, there are implied standards, principles, presumptions, and a dimension of morality. I go to slide 16. There's discrimination against the father if the child is born abroad and is illegitimate. So if the child is illegitimate and is born outside the federation, then under Section 17, the child's citizenship will flow from the mother, who may be a non-citizen. The Malaysian father carries no weight. This is the famous case of CTEB, where the High Court judge gave a scintillating decision by looking at the law as a whole. But the High Court was overruled by the Federal Court. The Federal Court basically went on the principle, it's not our job to make the law. Let me tell you this, in 55 years of teaching, I have not known of a single judge who does not sometime or the other make law. So of course they pretend not to. There is no judge whatsoever who does not sometime or the other interpret a rule creatively. But I know whenever it's convenient, they say, that's the job of Parliament, it's not our job. Now, the irony of this CTEB decision is this, that if the overseas child of a Malaysian mother and a foreign father is legitimate, the mother does not matter. But if the child is illegitimate, the mother's citizenship determines the child's status. A legitimate child cannot inherit citizenship from the mother if the child was born abroad. But an illegitimate child can. Legitimate child in our citizenship law is less important than an illegitimate one. Please don't get me wrong, I'm not condemning illegitimate children, but what I'm saying is in our citizenship law, a legitimate child is worse off than an illegitimate child from the point of view of gaining citizenship. Then no double citizenship is allowed, I can understand that. However, there are some problems. In the second schedule, it is provided that a person born on or after Malaysia Day within the Federation is a citizen by operation of law if he is not born a citizen of any country. In Azima Hamza 2023 case, the applicant was born in a refugee camp in Malaysia to Cambodian refugee parents who had fled their land. The court held that as the parents were Cambodians, the child was born a citizen of another country and was not eligible for Malaysian citizenship. I think this decision is heartless. It ignores the fact that the parents had fled their land. It was unlikely that they or the child would seek to build a life in the land the parents had fled. It is submitted that the second schedule, part 2, should be amended to not apply to refugees, asylum seekers who are fleeing war, genocide, and crime against humanity. Another very cruel aspect of this decision, unintentional cruelty in Azima Hamza, is that the parents are in the refugee camp. The child, however, is not eligible for citizenship. So basically the decision tears family members apart. Okay, then next slide 20. I'll just take 3-4 minutes, sir. Legitimacy. A contentious issue is whether a child born out of wedlock can be legitimized under the Legitimacy Act 1961. In Madhuvita Janjara Augustine 2017, the answer was in the affirmative. But sadly, Madhuvita Janjara was set aside by the federal court in CTEB, and there are a few other decisions. There is a special problem here for Muslims, because in Islamic law, issues of legitimacy have greater complication, because an illegitimate child cannot carry his father's name. The famous or notorious case of bin Abdullah 2019. Then there are issues of adopted child. An adoption order under the Adoption Act cannot confer citizenship. The right of the child born in Malaysia to citizenship arises only if at the time of the birth, one parent was a citizen. At the time of the birth, adoption had not taken place. So that means the child citizenship will relate to parents who may have abandoned the child, who may have run away from the hospital. So the funny situation is this: adoption is allowed, but the adopted child is not eligible for citizenship. So what happens then? What happens to the adopted child? Where does he go? Who feeds him? Who takes care of him? I don't know. Then registration of foreign wives. Under Article 15, a Malaysian man marrying a foreign wife can have his wife become a citizen after 2 years of residence. But if a Malaysian woman dares to marry a foreign husband, how dare she do that? She has no such privilege. The husband has to wait 12 years not to be entitled, to be eligible to apply for citizenship by naturalization. Then detention pending deportation. Many illegal immigrants who are arrested, tried, convicted, and ordered to be deported have no country that is willing to take them. What happens then? They are detained for an indefinite period. Article 5, Clause 4, 24 hours for normal arrests, 14 days for immigrants doesn't apply because no country is willing to take him. I think the law has to be changed to set a statutory maximum beyond which the detainee must be released subject to some conditions. My time, I'm sure, is out. I'll go to slide number 24. There are administrative measures that are needed. Identifying stateless populations is, I think, the first step to tackling the problem. Partly the problem is of xenophobia. These people are not security threats, but victims of unspeakable suffering. Then there are inhumane conditions in detention centers and refugee camps that need to be tackled. We have had death camps near the border. We have had commission reports. Reports were then put under the Official Secrets Act. Then there should be efforts at universal birth registration and documentation. I know that in 2017, there was a mega My Daftar and outreach program. I think this program must continue. The government must reach out with mobile registration centers to areas where the poor dwell, rather than expect the poor, the marginalized, and the uneducated to travel to government departments. Justice should go out to the kampongs rather than expecting the kampongs to come to the centers for justice. Then citizenship by registration and naturalization is there. Even if citizenship by operation of law under Article 14 cannot be granted, or the government doesn't want to grant it because that would disturb the ethnic ratios, even then I think there could be a discretionary grant of permanent residence, a red IC. And finally, I know this will be offensive to many, but I think officers of the NRD, Immigration, the Home Ministry must receive better training on what the Constitution and judicial decisions provide on the matter of citizenship. We need better legal literacy within government departments. Many NRD decisions are tainted by prejudice or ignorance. In case after case, citizenship rights are denied or delayed by the officers of NRD. I have some statistics here where actually something like so many applications were filed in so many years. 90% were not attended to, even though 3 or 4 years had passed. So I think there needs to be better education here. May I just give you the case of Haja Mohideen M.K. Abdul Rahman 207. A Malaysian male married a lady in India. He's a citizen. The children were born abroad. He applied for their citizenship under Article 14, Clause 1B. They were eligible because the father was a citizen here. The problem was that they were denied citizenship on the ground that, oh, they are citizens of India. Actually, in any case where the mother is a foreigner, there is this issue of a likelihood of foreign citizenship. So I think many decisions are basically in disregard of the law, in disregard of the possibilities. So I think there's legal literacy that is badly needed. Thank you very much.
Thank you, Professor Shad. What we'll do is that the next speaker is the Vice Chair of SUHAKAM, Professor Dr. Azia. Then we'll have 2 other speakers. And after they've spoken, we'll take questions and I'll moderate the session. I think there'll be an easier way to deal with it. Prof. Shad has summarized all the huge legal problems we have, identified all the main issues, the problems we have. It's not easy. It's a huge paradigm shift in how we deal with these issues has to be taken. So may I now invite Professor Azia.
Thank you very much, Mr. Raghu. Can we have the slides, please? I also have some slides. And I will straightforwardly talk about SUHAKAM on statelessness issues here. Sorry, my fellow panelists, ladies and gentlemen. Now, can we have the first slide? In terms of human rights, I think Prof. Shad has actually discussed all the relevant issues, how one could become stateless and so on. Yeah, and at SUHAKAM we also have a lot of cases, and I think I've talked about it a little bit in my speech just now. But I'm going to explain further in terms of what we do at SUHAKAM. So just very briefly, what SUHAKAM is, of course, the Human Rights Commission of Malaysia, and we were bound by the SUHAKAM Act, 1999, and under Section 21, we have our annual report to be submitted to Parliament, and usually, and only the 2019 annual report was debated. And we hope that this year, hopefully, our annual report will also be debated in Parliament. Now, in terms of statelessness, can we move on? Next slide. Can we move the slide, please? Okay. Now, pursuant to SUHAKAM Act, we have been doing watching briefs on an amicus curiae undertaken involving the alleged violations of human rights. And in 2010, pursuant to the consultation with the judiciary and the bar, SUHAKAM pursued court cases involving human rights issues. Watching brief and amicus curiae have been consistently increasing since its inception. So if we look at our data here, we can see that 2018, 2019, these are things that we do when we go to court. We do watching brief and on any violations of human rights. And if you can see 2020, 2021, and 2022, the number goes down because of COVID. But still, we still go to court when we are allowed, and we also send watching brief lawyers. Now, in terms of SUHAKAM, I would like to just say that in terms of what do, we base our functions on 4 functions. We advise the government, we look at law and policy in terms of human rights issues. Then we also do promotion and education, and we also listen to complaints, and we investigate these complaints, and also then through the complaints we also do watching brief and amicus curiae. Now, next slide, please. Watching brief and amicus curiae, watching brief cases on citizenship 2014-2022. These are the cases that we have been going on, and that we send our lawyers to do the watching brief, and we thank our lawyers for that. Next, please. These are the statistic numbers of complaint lodged on statelessness. If you look at the numbers, in 2018 there was like 413 cases, 2019 328, 2020 150, 2021 82, and 2022 it's gone up to 138. So these are the figures in terms of reports that complaint that come to us on issue of statelessness. Next, in terms of education and promotion, we have dialogues and human rights on human rights and statelessness. We have working workshops monitoring of immigration detention for senior immigration officers in Putrajaya. We also have workshops on understanding statelessness issue in Sabah. Now, I just like to say a few things before this, because the Office of the Children Commissioner was set up in 2019. I was the first Children Commissioner, and most of the statelessness issue comes to the Office of the Children Commissioner because it involves a lot of children. So that's how these figures also come out. But before that, it doesn't mean that SUHAKAM do not deal with statelessness issue before 2019. You can see that in 2018, the figures were like 413 cases. 2019, because I only came in September 2019, so all those data only come a little bit much earlier, and I only got that little bit from September to December. And thereafter, in 2020, 2021, that goes to the Office of the Children Commissioner, because we usually try to assist in whatever way we can in terms of, in particular for purpose of education, when the children wants to register at a school and also to get an IC. Yep, and when they were born, they actually they do get their birth certificate. Some have no birth certificates. And in Sabah and Sarawak, we have different issues, because there are cases where children, like the two generation parents have no documents, so children have also no documents. And there are marriages between Malaysians with non-documented person, and the children have no document because marriage were informal marriages. Yeah. Okay. Now I go to education and promotion. As I was saying, that these are the things that the Office of the Children Commissioner had. We organized this, and the workshop on monitoring of immigration detention for senior immigration officers in Putrajaya. That was something that we did to assist that. Well, it's a more of a collaboration for them to understand the issues better. Next, the slide that I can show you there. Okay, this is the signing of the MOU, I think. This is the Memorandum of Understanding with Human Rights Commission of Indonesia and the Philippines, and this was done in 2020. Then the Office of the Children Commissioners, I was saying to you, next slide please. We started off in September 2019, and since its establishment, the Children Commissioner made issues of statelessness as one of the primary agendas among many children issues during her terms in office, recognizing the exit of breaking generational cycle of statelessness starts from children. OCC has been rigorously advocating for the rights of stateless children with the aim of reducing the numbers of stateless individuals. First step was to, strategy is to bring the plight and contextual experiences into the eye of the public eye and numerous awareness programs and activities. Next, we also have visits and monitoring. This is where we went to, among the visit that we have, Kompleks Kebajikan Laila Type in Kuching, Persatuan Pendidikan di Wira Kuching, Orphan Care Foundation, Petaling Jaya, Sabah Ministry of Community Development and People's Wellbeing. And next, on more awareness program, we have awareness program on stateless children for enforcement officers, the Ministry of Home Affairs and National Registration Department, where webinar on right of stateless children and undocumented children, and also invitation as speakers for various online forum relating to statelessness. I think we actually invited the new Children Commissioner. We congratulate Dr. Farhanini to become the second Children Commissioner, and we invited her to be here today, but she has other commitment. But soon she will be taking over most of the issues on statelessness of children in particular. And next, we also have these are the slides of dialogue on session addressing statelessness and gender inequality practices, and then awareness of education program. And we also have brochures here in terms of, next slide please, brochures in terms of statelessness children in a Malaysian context. We produce this because there's so many confusion about issues of statelessness. As I said, a lot think that it only involves refugees, it involves some communities in Sabah. No, actually it involves all of us. And sometimes you didn't realize that you might have a cousin who married a foreigner and the children were born abroad and suddenly wants to come back and realizing that she couldn't bring her children back because they are non-Malaysian citizens. And if they do, then they have to go out of the country like sometimes once a month, every 3 months, sometimes a year to get the visa and also a study visa. So these are some of the problems. And we also, Office of the Children Commissioner had created and disseminated animated video on rights of children. And we, in terms of educating even children and parents about rights to citizenship and to reduce the flight of statelessness. I mean, before this issue of that, government decided to actually amend the constitution, I actually tell every friend of mine or even relative that married a foreigner for female, and I would tell them, look, if you want to give birth, if you want your children to have Malaysian citizenship, you make sure you give birth in Malaysia. So they have to come back like 3-4 months before they can deliver the baby, because otherwise, it will be a problem of getting Malaysian citizenship. So that is one of the main issue. But I also would like to look into, Office of the Children Commissioner, we also look into the issues of adopted children, which has been mentioned by Prof. Shad. I think the video that we saw on Datuk Tini's video just now, she also mentioned about the adopted children. And the thing is, when we are doing visits to all the children homes, particularly children home that even belong to JKM, Ministry of Women Family Development, even children in these children homes that belongs to the government are children without document. We have found numbers of children, they have no documents, they are non-citizens, and then they're worried because some of these children, by the time they reach the age of 18, they need to leave the children homes. What are they supposed to do? Where are they going? And most of these children are children that have been abandoned and are left with these children homes. So when we go and visit, and after we have a discussion and meeting with KDN, we actually said to them, the KDN during that meeting actually agreed that children in these children homes should be given a birth certificate and Malaysian citizenship because they were abandoned. Nobody knows who are their parents, and by right, it's an automatic citizenship, and JPN should actually just do not put the word tidak ada maklumat, no information, or non-citizen. They have no right to put that in that child birth certificate because the child was found at it was abandoned, and who would want to go around? And even now, there are cases where we actually put forward for them to get Malaysian citizenship, to get an IC, for these children when they come to the age of 12. The JPN actually said, well, we would like to know where was this child born. I mean, how does this children home knows where this child is born? Because the child is being brought, found at a bus stop, near someone's house. So we said, well, we can't bring you all this information. We even tried in one case, we even contacted the hospital. Somebody claims that this child was born at the hospital, but they have no record. So these are some of the difficulties, and I hope, really hope some of these laws needs to be changed for the sake of these stateless children. Thank you very much.
Thank you, Prof. Azia. Next speaker, very short, Malini, please. Then we'll have a question and answer session after this.
A very good morning, everyone. So I'll start with, it has been 7 years working on statelessness for me per se, and I know I'm one of the most youngest person who actually turned up working on statelessness and decided to meet everyone who have contributed so much. I want to acknowledge in this last 7 years, from not being able to speak about statelessness openly or accept the existence of statelessness, here we are launching a book acknowledging statelessness exists. And I would first mention, today in this room, I'm so proud that we actually have a formerly stateless person who's probably has decided to come up with his own statelessness movement to move forward with the issue. He's gotten his citizenship, but yet he wants to do something. And in the same room, I also know a parent of a stateless child who is representing on behalf of another movement. In that, I want to recognize every civil society organization, NGOs, who have been told yet again to you, stop working on statelessness because it brings us no money, but yet you moved on, representing on the issue. I speak to about these academicians who rarely come and meet us, but they speak our mind. And when we are struggling to look for references, they just appear and help us like God sitting next to us. I want to acknowledge activists who have used their networks and capacities to do all the works behind the doors, and specifically Dr. Tini for this, and acknowledging lawyers. They have moved mountains for us. That doesn't mean that we have gotten change of policies, but we know that this is possible. And this is very emotional for me to speak. As we speak about civil servants, I've met civil servants who have turned me down, and everyone else, and the kind of comments that they have passed on. But I also know of civil servants who have their heart for the children and passing on information just so we are in the right direction. And very lastly, since my current interest has been children born out of wedlock, I've been meeting religious leaders, and that's my current interest. And with that, I know a lot of changes is possible, but I know the challenges is beyond. And I know we need to navigate statelessness very carefully, but in all the conversation we have, I wish to go back to the first person, which is persons who are affected by statelessness. If at all, we can come up with, a statelessness determination procedure or a mechanism to protect them while we figure out the law, while we figure out the policies and everything else. What if we are able to protect them? And I really hope this conversation would be taken to, very seriously and implemented, because we have thousands and thousands and thousands of people who have not had access because of the delays in the, ensuring a procedural change or a law reform. So, yeah, that's from me.
Thank you, Malini. We also have Jasmine with us, but what we do is that perhaps in a question and answer session, we can deal with the issues that you raise, and each of the panelists, if you direct it to them, they can provide their views or solutions or whatever. I can start with Jasmine. Jasmine is a lawyer. She's done quite a number of cases involving statelessness and citizenship and adoption as well. Perhaps she can elaborate further on what Prof. Shad had raised in terms of the attitude of judges. You have some progressive thinking judges who are open to create law. You have judges who then fall back on the law to say that, look, I don't make the law, I just interpret the law. So perhaps Jasmine can assist us to speak about her experiences with the courts and judges. Thank you.
Thank you very much, Raghu. Well, I do not wish to comment too much on that, but perhaps what I could do is share my experience with a few cases that we've had. I guess most of us in the room would have known a lot about the celebrated judgment of CCH, which was released in November 2021, that actually concerns a teenager, a 17-year-old adopted child who was born in the hospital, but we do not know who the biological parents are. So after he was born, presumably the mother left him there with no contact details or information whatsoever about her. And the clients that we represented, the parents, the adoptive parents, they decided to take him under their care, raised him up until, 17 years old, teenager. And then they realized at the age of 12 that he has identity, citizenship issues because he could not get identity card. He only has his birth certificate, which of course says bukan warga negara. But at that point in time, the parents did not actually realize what exactly it meant. So fast forward a few years later, we started off right from when he was 12 years old and 13 to complete his adoption process, get both Malaysian father and mother recognized as his legal parents. But citizenship status still remained as bukan warga negara. So we started off in 2017 to bring the process in court, trying to get him recognized as a citizen on the basis that, look, we've got birth records showing that he was born in the hospital in Cheras in Kuala Lumpur. And these two and the couple, Malaysian couple, are his parents. But that itself apparently is insufficient to give him Malaysian citizenship. We were not successful in the High Court. It was also not successful in the Court of Appeal until we went all the way up to the Federal Court in 2020-21. The process took about, I would say, 1 year plus because of the entire judicial proceedings. We met with a panel of 9 judges there. So that was one of the expanded quorum because it concerns constitutional, because, citizenship laws are only provided in the federal constitution. So at that time, the former Chief Justice Richard Melajum decided to expand the panel to bring in 9 judges to rule on this issue. The question really at that point in time was whether or not a child who was born in Malaysia and then subsequently adopted legally under the Adoption Act would get Malaysian citizenship. We have known the position from the defendants, the defendant government, whereby they say that the Adoption Act is silent on citizenship issues. And that is very clear. It's not stated there compared to, let's say, Singaporean. The Singaporean Adoption Act, Section 7 says an adopted child will not get citizenship. But if we were to look into other countries, they would say, okay, adopted child would follow the citizenship status of their parents, of their adoptive parents. So Malaysia is that silent for us. And the government went on to say that, look, because it is silent, it is clear that the parliament did not intend to grant citizenship status to any adopted child. But when the case actually was heard in the federal court, the panel asked the defendant, the solicitors for the defendants, whether we know or whether we have any information on the child's biological parents. And that fact is not disputed. Nobody could give a name, any details about the biological parents. And it was considered at that time that the child was abandoned. So what the judges did, the majority panel, they actually read the constitution as a whole. This is where Prof. Shah actually said that they look into the history of the constitution, and they could see that, you know, the party at that time, they wanted to include as many categories as possible to be the citizens of Malaya. And they were looking into various categories. Of course, now we are experiencing the consequences of some categories which were not explicitly mentioned. But the intention, the federal court judges realized the intention is that they want to include as many people as possible, and it could not have been meant for any abandoned child to be left, fall through the cracks and not get citizenship. So that was what the judges did. They interpreted with the purposive approach, looked at it, trying in so many ways so that a child like that, and a child who was abandoned at birth, no information on his parents, and then subsequently adopted by Malaysian couple, would get citizenship. So that is one of the progressive decisions that we saw. And although that was a very, very good decision, because that would mean the lower court decisions would be bound by it, and that the JPN officers also would be bound by that decision. But I have to say, 1 year later, 1+ year later, we are not really seeing much cooperation from JPN. Because yes, we have seen quite a lot of success after the decision of CCH by the federal court, whereby many of the lower court, they decided to follow it. As long as the child was born in Malaysia, found exposed and abandoned with no information about his parents, his or her parents, they would get citizenship by virtue of CCH decision. But the opposition that we have gotten until now, the government is still going to court and questioning whether or not the child is actually abandoned. So then we have the issue of, okay, the child was found abandoned in the temple. The caretaker in the temple took the child, went around society, shelters, children home, asking, okay, is there anybody who could take the child? The child was then passed on to a third person, and then somebody else passed on to the child to these potential adoptive parents who then adopted the child. So the question of, you know, the chain of custody, whether or not by finding the child in the temple, passing on to the third party, and then passing on to here and here and here, would that actually qualify as abandonment in that sense? So that is the issue. If we cannot prove abandonment in court, we have seen some decision where they would reject the argument that the child is abandoned, and that means the child would not get automatic citizenship. So yeah, that would be it.
Thank you, Jasmine. Can I now invite questions from the participants? Please keep it short. Um, 1 minute each. Just put your questions right to the point. And solutions, what you think we should do. We know the problems, we know the issues, your experience and how it's been successful, the problems you have, and maybe questions you have to the panelists. Thank you. Yes. Yeah. Oh, sorry, you can take the next one. If you can stand behind him, then easier. Someone, I think. Introduce yourself and you can state your question. Oh, you use that.
Hi, I'm Casey from the Stateless Malaysian Citizenship Movement. I would like to address the word illegitimate. Illegitimate, right, is a direct violation of a human right. Shouldn't use the word in the federal constitution at all, right? Maybe we can change that word in the federal constitution.
We'll take that again with a few more questions. That's your point. Next.
Hello, good morning. I'm Dr. Rosiana from International Islamic University. I've done some research on statelessness as well. My concerns or questions, I think, would be to all of the panelists. I would like to know whether Malaysia is ready to implement statelessness determination procedures, and what would be the impact of that? Because as Prof. Shad Faruqi has explained to us, we have item 1E of part 2 of the Federal Constitution, which is, I think, which forms one of the strongest my question is, how would this statelessness determination procedures work out in the context of item 1E of part 2? Because it says every person born within the federation who is not born a citizen of any country is entitled to Malaysian citizenship automatically. How should we, do you think we should differentiate between in situ and migratory contexts when we apply statelessness determination procedures? Because as far as I understand, those who have links with Malaysia, with the country they're born in, and they have lived in this country for generations, have no links or connection to another country, I think the approach is slightly different. We should have what is called as nationality verification, which is also in line with nationality campaigns, to allow these people to be recognized as citizens. And this would refer to those, I think, long-standing populations who have lived out in Malaysia, even prior to independence, but are not documented. So what would be the approaches to these different categories of at-risk and stateless persons?
Can I request for Dr. Shad to answer these two questions? One is the definition of the word used, illegitimate. should we use another term which is more, what do you call it, not so stigmatized? And the other issue is the statelessness determination procedure. Prof. Shad mentioned it earlier as well. How do we go on and determine these issues? Then we'll come to the next question.
On the first one, the word illegitimate, the speaker did not recommend an alternative. Perhaps you should recommend an alternative. I'm afraid we have to adopt a broader perspective. There are issues of ownership of property, succession to property. There are issues of marriage. So there are lots of religious issues involved. I'm not one of those who says religion is not important. I'm afraid nothing is irrelevant and everything is relevant. If you want to adopt a holistic approach, then I fully acknowledge secular beliefs, modern beliefs are important. I would not agree that religion, morality and traditions are not important. So I would request you, what other word do you wish to propose for those who are born out of wedlock? Maybe instead of illegitimate, we say born out of wedlock. That would be fine. If the word illegitimacy, yes, I agree with you. It carries a lot of negative connotations. I have no objection to changing the word, but the fact of the matter is that there is an institution of marriage. I know that many people are having children outside of marriage these days around the world, but the institution of marriage is strong and will survive, and I think the law must take note of it. So that's my answer to the first. The second one is a little bit difficult, Dr. Liana.
The statelessness determination procedure, how does
Yeah, in terms of statelessness determination procedure, somehow as I was researching, I felt that this was an immediate solution that would be helpful for Kajian particularly, simply because even before we speak about 1E, I feel all of the childhood statelessness cases is actually clubbed into 15A. And today the problem is they are unable to identify who is stateless under the 15A and who has perhaps another country's citizenship to fall on. And they use that same argument against us, right? So I definitely feel a statelessness determination procedure is very, very important so that we can pull out and then rightfully place them in the right categories and offer them the right protection, because an SDP is a temporary, it's not a solution, it's an interim thing to provide protection. But to your question, whether we should have different ways to categorize them, especially we speak about in situ and migrational context, and to acknowledge the fact even UNHCR actually encourages SDP only on migrational context. But I believe SDP works in our context, especially in situ, simply because it relates to marriages across border, but they are living in Malaysia. So I definitely feel that's something that can be applicable, but definitely it requires procedures to differentiate even within in situ. And we cannot have a blanket SDP for every stateless person. I don't think so. It won't work. And on top of that, knowing how our ministry, or rather our country, approaches citizenship, as one who gets a citizenship, I think that's what would work in Malaysia.
I think we need to distinguish between the status of a newborn child and status of someone, let us say, who's a refugee or an asylum seeker. In the case of a refugee, asylum seeker, I know in some cases lawyers have tried to assist their client writing to the Indonesian embassy and saying, please tell us, is this person
in your report. And the embassy says, no, we have no such records of the person. So in the case of adults, I suppose it may be a little bit easier to determine whether they do belong on the citizenship register of a country. But in the case of a child, issue is simply one of eligibility. Obviously, the child doesn't have papers as yet, eligibility. And I think it is totally wrong of us to believe that there is one and only one eligibility. In fact, may I mention to you Article 14, Clause 1b. All that is necessary is for one of the parents to be a permanent resident. Permanent resident means he still has his citizenship from somewhere else, which means the child may well be eligible for citizenship there as well as citizenship here. So this idea that there is one and only one eligibility is wrong. I think the law of citizenship is incredibly complex. My personal view is this: as long as one parent acknowledges that he is the parent, he or she is the parent, and the parent has connection with this country, the child should be able to inherit. That's my view. Thank you.
So my former also a very good one. I'd like to direct this question. My name is Vikar Ahmed bin Muhammad. I'm from the Islamic Organization. I'd like to direct this question to Prof. Azia regarding about the report on the stateless issue, and also you all witness cases of stateless which are going through the judiciary process in the country. Because for me, for my understanding, that when the reports goes to the parliament or goes to the government, especially cabinet, it would be like stuck over there. It doesn't move from that report, because it should goes to the parliament to debate, and also goes to the select committee to decide what are his finding, and there should be what you call this, a panel of a committee look into this report and to study and what are the implications, and also to find out more in detail what are the weakness and what is the loopholes in this system. How does the SUHAKAM or the missionary body to look into it from the perspective of the government addressing this issue? Because, like for example, like my case, my mom was a foreigner. I was born in abroad. It took me 2 years to get my citizenship, but it's not going through the judiciary process, but it's all about the administration and also technical. This process actually same happens to me when I married up to a foreigner. Also, it took me a very long time to process. I just want to know what is the weakness and the failure of this institutional in order to grant the citizenship process. But like other countries, like example, where like others, my family related are living in UK, they might be granted like 2 years, like Canada, 2 years programs, everything. It should be like into more modernized system. That's my first and my final question is to Jasmine. What are the weaknesses when the judiciary come out, especially the federal court, come out with the judgment regarding about to issuing citizenship or any document to a person, but when it goes to the gatekeepers, especially the National Department of Registration, they does not fulfill the requirement from the judiciary. What are the cause of this failure from the side? Thank you.
I think the first question, problems that we have, I think Prof. Shad had explained it. It's race, religion, ethnicities, awareness, understanding, and it is so intertwined in the sense that it's seen as a security threat. Are we increasing the number of non-Malays? Are we increasing the number of non-Muslims, for instance? So that is one of the biggest hurdles that it faces. And I think what Prof. Shad also mentioned is it's not a security threat. In terms of numbers, it's nowhere close to being a threat to any race or religion. That's number one. And number two, I think the issue is also this. It's intertwined it's complicated in many ways, but I do not think that it cannot be resolved. I mean, Malini spoke about how now we have a report being officially launched today. 10 years ago, it would not have happened. I mean, this was seen as so difficult issues. The judiciary would have never touched these cases. 20 years ago, no way, right? So we have inroads. We have a minister now coming up to say that we'll amend the law, the constitution even, right? And in June, it's coming up. So there is light at the end of the tunnel. It is not going to be easy. There will always be issues. And I think a lot of people feel that we should look at the federal court, decisions pending, of the issue of citizenship of spouses. I don't think that's the solution. I think the best solution is amendment to the federal constitution. That would be holistic, that would deal with all these issues we have. But I think, I mean, we at SUHAKAM, we have serious problems of communication with certain stakeholders. Ministry of Foreign Affairs is fantastic. The prison is amazing, very good, helpful, very progressive in terms of dialogues. Of course, the most difficult and the most irresponsible and the most non-responsive is KDN. Hopefully, the new minister will get some headway and we get to get some changes. I think some of the problems we have is this. When we launched at the early part of this launching, 4 children came up, right? I mean, the impact of seeing children launching and being part of this process opens your eyes and creates a bit more empathy to the issue. So I think at SUHAKAM, what we've now decided is that before we speak to non-responsive stakeholders, we'll show a video for 1 minute or 2 minutes of a child. We're talking about a child who's having problems at 12. I can't go to school. I can't take part in the school sports. I cannot take part in many activities which my friends are taking part in because I'm not a citizen. I can't travel on a holiday because I do not have a passport. So I think to get people to speak, a child who speaks and articulates the problem, it will create a little bit more empathy. So I think for courts, I mean, I'm a lawyer as well, I think you should bring a child to court. Not to argue the case for you, but to sit there so the judge will have to face the child when he or she makes a decision. That will create a bit more impact because you're actually putting a face to the person who has a problem. Otherwise, it becomes a legal argument which does not have any impact on me or anyone listening to it. So perhaps we should change the way we deal with these issues. I mean, we speak, we are all converted here. We all understand the problem. We know what the problem is. But how do we now go past one more barrier? JPN. Right? I mean, everybody has spoken about the problems here. Malini has explained the problems she had, difficulties she has, but there are also people who are supportive. We need more of them to understand the problem. So one issue is this, the report is in English. It's a fantastic report, but what SUHAKAM is going to do is probably simplify it into Bahasa, distribute it to all the stakeholders as well in a simplified form, press release again in point form, you know, and this is how perhaps we should approach the issue of statelessness. Jasmine, sorry.
No worries. I believe the second question concerns about the enforcement of court orders in JPN or KDN. I do admit that time is always the issue here. Right from the start, before the issue of citizenship gained traction in media or within public, many years ago, let's say 5 years ago, when we first initially got a court order and we brought it to JPN to get it enforced and get a new birth certificate for the child. The comment that we received from JPN officer is that, look, ini adalah perintah mahkamah. Mahkamah lagi besar ke atau KDN lagi besar? So they are essentially saying that, okay, court order, you have a court order, good for you, but still we are the deciding, we are the person to make that decision whether or not this child will actually get citizenship. Fast forward a few years later, I have to say, fortunately, if we've gotten a court order and we bring it to JPN to enforce it, provided there is no appeal in Court of Appeal or Federal Court, JPN officers will go through, will see to it. But one thing we realize is that even though the court order actually specify that JPN needs to reissue the birth certificate or issue out the my kid or my card to the person in question within 14 days of the order, or 14 days from the day they were served with the court order. It doesn't actually take place within 14 days. JPN still take about, I would say, 3 to 4 months to come up with a simple document, identification document of birth certificate, or to print out the IC to the child. So what is the question that this is something that we would like to ask the officers as well, because we already have the court order, and if there is no appeal, that should be the deciding factor. And even if there is an appeal as well, if there is no stay order from the court, JPN should give effect to it. But practical wise, that is not what we are seeing on the ground.
If I just want to add to them, in actual fact, they are in contempt. Yeah, but however, because the interested parties, they really want to have this document. So most of the time they waited and they layan je lah for that document to finally emerge. But I just wanted to answer the question on SUHAKAM's report. And SUHAKAM, we prepare our reports annually. We submit it to Bayu, for the various process before it ends up in Parliament. And we were very fortunate. Ever since its inception in year 2000 until 2019, it's only in 2019 that our report was debated. Yeah, I mean, it has been sent, it was laid in Parliament, but it was not debated. But 2019, it was debated. And we were hoping that our reports, 2020, this year in particular, with a new Parliament, government in Parliament, so it will also be debated. How do we follow up, with our reports? Usually our reports are published and it's online, and it is accessible to the public, and we could actually read what's inside. And whatever things that we do, all the divisions, it's all reported in our annual report. And I think if there is a question in Parliament on issues that on the report that we have prepared, then the minister in charge would be able to answer. And we were really hoping that, in fact, the commissioners has just recently met the speakers, and we were hoping that, and YB Azalina actually said in last year that she was hoping that to give SUHAKAM a better a review of the Act, and then we are able to be in Parliament during when our report is being debated. But that will take time because we are waiting for our law to be amended. Yeah.
Let me just add something to the issue faced by Yasmin just now about judicial decision not being implemented or being implemented with great delay. In your case, you said 3 months. In the Indira Gandhi case, it was 2009. Now this is 2023. Until today, the court order has not been implemented. Well, I think there are several problems. One is there is lack of constitutional literacy within the public services, within the citizen. There is lack of constitutional patriotism. There are lots of people who just do not believe in the Constitution. I'm sorry to say that. I've been a teacher of constitutional law, but that's my impression. They say, oh, well, It was drafted by the Reid Commission, so what? uh, and they give many other reasons. There is no internalization of the Constitution. There is also this problem, and this is probably existing in other countries too, that the perkililing of the department, arahan, or instruction, directive, is regarded as more important than the law itself. I have been a legal advisor to my university. Sometimes I go to the ministry and I say, but sir, that's what the law says. And they will turn to me and say, you don't know the directive, ka? So I say, yes sir, but look at the law. But their view is that the directive prevails over the law. The directives. So I'm sure in your case, I'm sure the officer is consulting. Bole ka? and so the officer consults another officer. That's why the delay. Nevertheless, I think we should have hope. As Mr. Chairman pointed out, things are changing a little bit. Parliament's committees can ask questions. During Su'al Jawab, questions can be asked. I think there are more and more NGOs who are standing up, who are throwing small pebbles onto the placid surface of the lake, and that is causing ripples. I'm told that in the desert sometimes a sand dune grows around a single blade of grass. So I think that's what needs to be done. Don't forget, we are only 65 years old as a nation. I remember during World War II in the USA, habeas corpus was issued to the executive, and Roosevelt, President Roosevelt, otherwise an honorable man, said, all right, let me see the Chief Justice enforce it. In other words, he's not going to enforce it. See what the Chief Justice can do. I know the Chief Justice can, well, not in the case of the President, there is power to punish contempt of court, but I don't think the President can be punished. But in the USA, after 200 years or so of constitutionalism, the President challenged the Chief Justice, see what you can do. So I think we can have hope that with constitutional literacy, things will improve. But this is a process that takes time.
Thank you.
Hi, good afternoon. I'm Yuli. I'm a stateless Malaysian and also a subject of this report. So I want to put on record my gratitude for this report. So my question maybe to SUHAKAM or NGOs leaders out here, are we expanding the scope of focus on statelessness to not only stateless children, but stateless adults, given that SUHAKAM parks stateless issue under OCC, Office of Children Commission. So like what Dr. Melati said, children will become adult eventually. So the question in a simple form, are we ready or are we going to put more focus on stateless adult? Thank you.
I think the issue of statelessness is not only limited to children. So again, the issue in Sabah and Sarawak, for instance, so huge problems. They are in the interiors, that problems that they did not bother about getting their my card or registration, or they went to school. But at some point, they probably applying for a job somewhere, and then they realize that, oh, I need my card, right? So it is there. These are issues that we have to deal with, and it's a subset of the problems that we have. It's not that it's being excluded. These are things that is part of the process. It is still a human right.
And the thing is, what happened is that we'll start at OCC because a lot of it is children issues. Bina is already standing there, and she was the one that actually, highlight to us a lot of these stateless issues on children. But once they come the age of 18, we will pass it to the division, complaint and monitoring division. They will pick up that issues, continually pick up that issue and bring the matter forward. But what is going to happen with the amendment of the Constitution, we wanted to know, we really hope that with the amendment, those who have been denied citizenship while they were a child and now have grown up like, being an adult, and some actually, going to their elderly age. These must be included in that amendment of the Constitution, because we are not just focusing on women who married foreign men and the child was born abroad, but we are talking about those children who had become adult, has also having children and married abroad, and these are the issues that we would like government to look into. And seriously, this particular amendment, and we also like them to include issues like adoptions, the legitimacy issues, legitimate and illegitimate children. These must also be thought of and be included in these particular amendments.
So just to go back, it does not literally mean children, as at least for civil society organization. We have to remember the term childhood statelessness was used for basically to indicate that you're born stateless. So until statelessness ends for you, you are under the category of childhood statelessness, but that doesn't mean that we won't work on you. We will, we should.
Yeah, and just to actually say, I know a lot of the focus I've actually zeroed in on children, but even in court itself, we are representing stateless adults. And adults, we have clients who are in 20s and 30s and 40s, so it doesn't actually stop at the age of 18 or 21. It affects adults too.
Okay, before I invite the next participant to ask questions, there's some questions from which you have received online. Just very briefly, we hope KDN, JPN allows abandoned child that biological parents are unknown, but adopted by both Malaysians be allowed to get automatic citizenship upon adoption, or do they still have to go through the level of applying for citizenship? I think the question has been answered by Jasmine. Case law says that there is an issue that you have to prove that there is abandonment. Then it becomes that one hurdle that you have to cross. Okay, the next, sorry, I'll come back again. Next question is that, again, I mean, so much debate, but no action from the government. So this is a question we have. Why is JPN reluctant to apply the law? Ada beberapa kes yang telah mendapat kerakyatan di mahkamah, tapi JPN tidak memberi kerjasama yang baik. Perlembagaan persekutuan bahagian kewarganegaraan agak jelas sebenarnya. Soalan saya, mengapa JPN tidak praktik undang-undang tersebut dalam proses permohonan? So these are questions we've received. I think along the way it's been answered by our panelists. Yeah. You want to go first, and then Siva. Sorry. Sorry, Bina.
Okay. On the issue, Prof, where you said that the citizenship should also be accorded to those who are adults. So according on the automatic citizenship for overseas born children, we were successfully able to submit applications for those who are above 21, and JPN says that citizenship by operation of law does not have any kind of age limit to like 15A or 15.2. On another note, under 15.1, which says Malaysian husband can pass on citizenship to his foreign wife after 2 years of residency. Is it just 2 years of stay in Malaysia, or is it after 2 years of permanent residence? Prof.
The law uses the word residence. The department has interpreted the word residence to mean permanent residence. Permanent residence is discretionary. So basically, it's up to them to whom to grant permanent residence and to whom to just simply give a pass to enter, then leave and enter again. So the government department actually is interpreting the law creatively and politically.
Yeah, and it's also really sad that many of these foreign women who live here for many years are just on a visa and so dependent and bounded to their husbands, which makes them vulnerable to gender-based violence. On another note, if the issue of dual citizenship keeps cropping up only when it comes to Malaysian children, overseas-born children of Malaysian mothers. Okay, it's time and again, we had the previous law minister bringing it up. We have even this law minister saying, because of dual citizenship, it's been, moved to maybe June parliament sitting. But the same case is also for children of Malaysian men. And why is this being brought up only exclusively for citizenship of Malaysian mothers? And it's used as an excuse, because when a Malaysian mother goes to register their child at the embassy, sometimes they are in a third country and they don't have any citizenship, and they want a travel document to come back and apply Malaysian citizenship. It's not given. And yet that is used against these mothers in not according them citizenship. But tell me, isn't there a remedy in the constitution that says that after 21, a person has to only choose one citizenship? Can that not be used?
The law doesn't require you to renounce or what. It just has a deprivation provision to say that you cannot have two citizenship.
Okay.
And if it is proven that you have to, the federal government can then deprive you of it.
Okay. But so there's no remedy that we can say that these mothers can have in terms of, why is this dual citizenship only used as an excuse not to grant them citizenship? There's no answer to that. Okay.
No, I think we are with you. I don't think it's a valid excuse.
Okay.
Just to answer you in relation to, I think even the previous participant, why the government or civil servant JPN not doing anything about all these court orders, and we in fact we had a meeting with them twice. The first meeting whereby we actually explained the different basket, we call it basket, different categories of children that are stateless, and without citizenship. And then we actually apply, or rather told them that in particular children in children homes should be given. And during that meeting, the KDN plus JPN agree that children in children homes will be granted automatic citizenship, meaning with the birth certificate, once they make a police report, take the children to JKM house, take the child to the hospital, then they process the birth certificate. In that birth certificate, they no longer will put tiada maklumat or foreign citizen. That's one. But when I go and visit from the date of the meeting until today, when I visited all the children homes, the pengetua will tell me that we have a number of children with no non-citizen. They have no document. They have document. They are non-citizen. But I said, well, we have already, the agreement has been made with JPN, and they should have not registered the child as non-citizen. But what happened is that meeting, whatever we agreed, do not go down. That's one issue. The other thing, even when there is a court order to grant them citizenship, that order, it must be like, it goes to the first person in charge, the KSU, and then it goes down, and it must be through pekeliling that Prof. Shad was talking about, must be sent to all the counter persons, so that now, when there is an application from abandoned children, from adopted children, you must take the application and you lampaikanlah, you put in the adoption order from the court. That child should be given automatic citizenship. But then again, that also has not happened. So this is some of the problems why, when you have a court order, when you have meetings, an agreement between KDN, this thing do not, go down to the person in charge at the counter. And also there is no SOP. What we actually wanted was for application of birth certificate, this must be the SOP. For application of citizenship, this must be, and they must follow that through. So this is, we hope it will be done through these amendments. It must be sorted out as soon as we can, yeah.
I'd like to direct to you, Mr. Raghu. We came forward out in 2019. We went to see the minister then, Muhyiddin, at the Home Ministry, right? About 300 of us went there, and we represented about 153 children who were stateless, right? And so far, till today, we have only about 20 approval cases, all right? And we have followed up with several letters, and most of them are unresponded. So what can we do?
Working on human rights, the last 30 years, as a lawyer, there's always hurdles, right? But I think one of the things that I've learned from people like Siva, my senior, is that don't give up. That's one. Never give up. And battles in court, which 20 years ago seemed impossible, cases that I've taken up and, I said, look, he's a trespasser, he's a squatter, he's got no rights. Siva said, no, fight. At some point, you will get recognition, right? Similarly, with statelessness, it's when 20 years ago, it's hopeless, right? Impossible for any judge to be with you. Impossible for the government to be responsive. It's impossible to have a conference like this or talk. It'll immediately be sensitive and no permit, and there'll be a raid, and people will be arrested. That was 20, 25 years ago. Look at where we are now. I understand the problem. I accept that it is difficult, but I also have hope. I have faith that it will change. And imagine that you have two important ministries, the legal affairs and the home affairs, coming up to say that we will now amend the federal constitution. That's amazing, right? But the follow through is important. Of course, there are hiccups, there are hurdles that we have to look at, but I think we should push. We should push in many ways. What you did was amazing to get so many people to go up and see. The fact that he met you is amazing, right? But this is a process that has to keep on going. We have to push, we have to fight. Before Prof speaks, maybe Siva, and then I ask Prof.
Thank you, Mr. Chairman. I don't really have a question. I just wanted to share two concrete experiences quickly to help us understand, I think, what Prof started off with by saying the problem of statelessness is not one of law. Yes, law is a factor, law plays a role, but as you've mentioned earlier, race, religion, etc. I want to add an extra word to it and share a very concrete experience. I want to put the word in ideology. In reality, there is an ideological issue within KDN, which is historical. Its roots are historical and it's persisting, but I think there is hope. It is being diluted, and I think as hopefully this government now talks in much more inclusive terms and so on, that will dilute. Let me give you the quick example. I ran 2 citizenship clinics in my, sorry, I should introduce myself. I'm so sorry. Siva Rasa, former member of parliament, 3 terms in Sungai Buloh. Now, I ran 2 citizenship clinics in my area. I think it must have been before 2018. This is 9 to 5. We just invited people with citizenship issues to come and see us. I had the cooperation of Selangor JPN, who sent 10 officers to document and then take the files back and see what they could do. So during the lunch break, I'm just dropping by. I had a chat with one of the middle JPN officers, and I asked him about Article 14, because as Prof. Shah rightly pointed out, it's a very generous provision. You're born in Malaysia, one of your parents is a citizen or PR, just PR. You are entitled to citizenship by operation of law. It's very clear. So I said, why aren't you applying this to quite a few of the cases? Then, this guy was honest. He was a bit naive, but he was honest. He told me straight, but itu untuk bumi putra saja. So I said, I didn't want to debate with him. I mean, this is a middle-level officer. So I said, ada berkeliling ke? He said, no, this is now latihan. So there are, in other words, there is an ideological slant or bias to the training. That's real. Ironically though, when I saw the numbers, we had a large turnout in both clinics, one in Kota Damansara, one in Pajaras. And unlike some activists who present the citizenship issue as an Indian issue, it's not. In the Kota Damansara clinic, 70% of the people who turned up were Malay Muslim. In the Pajaras clinic, it was 95%. People that didn't have birth, children without birth certs, mothers who had gone back to their original countries, all sorts of problems. But it was so revealing, it was not a so-called Indian problem or, as sometimes projected, but it is now the majority group who is experiencing the problem. So just to share that so that, and okay, the final experience is, which is documented in your report, page 235, when PH took power into 2018, myself, a few other leaders, including ministers, we persuaded the Prime Minister to make that statement to say people with red ICs living old age, 60 plus, they should just be converted to blue ICs. So we organized a meeting with KDN to say, can we just write down a simple SOP? What's needed so that when they come, they are clear. KDN immediately said, no, we follow the law, which is you must show good character and proficiency in Bahasa. So we said, can you be flexible on Bahasa? Oh, we'll think about it. What about good character? Special branch has got to give us a report. That takes 2 years. So we had one meeting. Muhyiddin couldn't chair because at that time he was not well. The deputy chaired. All the top brass in KDN and all there, including JPN. One meeting, we were supposed to have a follow-up meeting. It never happened. And we're not sitting there as ordinary citizens. Huh? I'm sitting there as a deputy minister and I have ministers in my entourage. And so I'm just explaining these experiences to show there is the ideological barriers to what we are trying to do. But I think the good news, there's hope, as Prof. Shah said. I think it's being diluted. Just to perhaps help us all understand that that's part of the battle as well. Then you need a government that is going to think more inclusively in a different way, recognize the realities of the problem. And I think the answer is in the Home Ministry, not so much in the Law Ministry. The Home Ministry is the decision maker, is the driver, is the person, is the ministry that's going to change JPN, if at all. So we have a good start with the mothers, the children born to mothers overseas. Hopefully that will all be resolved this year with the constitutional amendments and clear procedures after that and so on. And we keep making other changes now. But I just wanted to share that quickly with
Thank
all
you.
of you.
Thank you, Siva. Last question, then we'll have a roundup for 2 minutes from each of the panelists.
Hi, good afternoon. Siva also from PSM. In agreement with all the panelist speakers, but maybe Prof. Shad or Prof. Dr. Azia also can give some response. We knowing that all of these things are not only based on documentations, there's a story to be told upon all of these cases. So is it fair, I would like to get a response to propose that besides the bureaucrats making the decisions, if they are rejected, why don't we set up a separate tribunal where the cases themselves could come forward and explain their story beyond the documentations, something like in SOCSO cases, when you get rejected, you have a fair time in a tribunal, probably could be seated by ex-judges or something, so they can look at all the other aspects. Because now it only looks like the only recourse we have, which not many of the B40 would have, would be the legal side. And of course, the ideological battle, like what Siva related. So is it a fair proposal to say that, okay, JPN, you have a lot of cases to do. The bureaucrats, maybe they are competent, maybe they are incompetent about the law. They look at the directive above the law. So why do we set up a separate tribunal? So that at least we can have a different opinion and hopefully the KP will accept the decision of the tribunal. Yeah, thank you.
Thanks, Siva. Very good suggestion. So now I'll invite Malini, then I'll take 2 minutes each.
Actually, if I can shed light on this, this is one of the recommendations where we put forward around 2016, and then the government told us to do a mega My Daftar exercise alongside with them. So to be honest, in all the My Daftar initiative, DRA was actually training all the ground staff, and we were trying to follow through everything. And so part of it was that we need to have a task force that would actually look into the cases and know the story of the cases and know why putting through again and again some processes wouldn't work. So, and I think and I believe SITF was created for that purpose, but despite being under the PMO, they never had an entry to KDN. So if at all we're going to do something, I think it's very important for us to recognize that whatever task force that comes needs to have an access to KDN, or else it means nothing. I mean, it will appear on news everywhere, but it means nothing. So as a, are we concluding, right? Yeah, as a conclusion, I would say it feels very emotional, but at the same time, I want to recognize my fellow colleagues here who basically it seems like they're doing their own thing, fighting their own battle, but it's definitely seeds that has been thrown so deeply in so many places, and I know we are meant to come together, and we will, and I can't really wait for, in years to come, we would address statelessness if it's not ending statelessness, if Prof said. So thank you.
Well, I actually was interviewed by a journalist as soon as government announced that they will actually amend the constitution. So I said, what happened in between while waiting? And I do know a lot of parents, a lot of mothers are concerned because their children's visa are expiring. And I was hoping that as of waiting for June, KDN, JPN must have a temporary procedure to process some of these temporary visas or extend their stay while waiting for them to get their citizenships processed. And I'm really hopeful that the amendment will come through and the proper procedures of application is laid down properly so that there is no, in terms to me, delay is our greatest enemy in this case, and we are talking about children, and I really hope the issues of legitimacy, illegitimacy could be resolved, because we are not punishing the children. It's not the children's fault. We are talking about the children's right to citizenship. Thank you.
Thank you.
I think I would just like to say that I have always advise, or rather tell people to spread awareness on the issue of statelessness, because if we know about this issue, but a lot of the general public, they don't, and they did not realize how the issue of statelessness and citizenship actually can affect your siblings, your family, your cousins, neighbors, society as a whole. So with the lack of understanding from people about this issue, then it becomes much more difficult for there to be a cooperation between departments, societies, and even among the department officers. Because whenever we speak to the officers, one thing we can say for sure is that they do not understand what being stateless mean. They always have the understanding that a stateless individual means they come from a different country, and they are trying to invade Malaysia and trying to make it their home country, you see. So that is why that is something that they guard so very tightly. But that really could be resolved with the understanding of the issue itself, and that would start with spreading awareness about the whole issue as a whole.
I have two comments to make, Mr. Chairman. One is this, that Yasmin was saying that when you ask the registration department why they are not issuing the papers, they give very general replies. In administrative law in this country, developments have taken place where courts are saying if a decision is to be regarded as rational, it must be accompanied by brief reasons. So I wonder if courts could be encouraged to order the registration department, when it rejects an application, give brief reasons. I'm not talking of a 5-page, no, maybe in 5 lines. Why was the application rejected? So that's one thing. Secondly, I want to make a request to the distinguished members of SUHAKAM and all of you lawyers who are doing such a great job advocating. You're talking about automatic citizenship, citizenship by operation of law under Article 14. Can I humbly recommend that perhaps don't go for operation of law, go by registration. 15A, subject to Article 18, the federal government may, in such special circumstances as it thinks fit, cause any person under the age of 21 years to be registered as a citizen. This may be easier. Or permanent residence. The issue here is not simply the piece of paper. The issue is the right to vote, the right to medical treatment, the right to education, the right to have a bank account, not to be subjected to harassment by people who are seeking bribes from you because you don't have proper papers. So maybe this problem could be resolved temporarily by permanent residence. Permanent residence doesn't shut the door to citizenship ultimately, or registration. So I know that citizenship by registration is lesser. A citizenship by operation of law, which you all have, is the highest type. You have a right to vote. It cannot be taken away. It cannot be taken away. People wrongly believe that it can be taken away. No. Registration and naturalization can be taken away. So I know that, but perhaps if the government is reluctant, my final point is I see many Arab countries where actually you have millions of workers, but they are not citizens, they are on permits or they are on permanent residence. Maybe that could be a middle solution. Thank you so much.
Ladies and gentlemen, thank you very much. I think it's been really enlightening. And if any of you want access to any of the slides or what you have, please write in to us, especially Professor Shad's detailed provisions in law. Please write in to us. And if you have any views on our report, please write in to us again by email. Yeah, and please help us. This is a fantastic opportunity for us to learn as well from so many of you. You have academics, you have lawyers, you have social activists, you have people who are concerned about this issue. Let's not give up. I don't think we'll give up. We have to work harder on many fronts: courts, advocacy, awareness. SUHAKAM has to play a bigger role as well. We need to up our tempo, work harder, and get things done. So the momentum is there with the government, Masyarakat Madani, the Madani government. So let's use that. Let's work with them. The 2 ministers have come up and said that they will look at the amendments. I think this is the time for us to tell them what's lacking, or how do we propose the amendments to be, and what do we look at? Interim measures, for instance, perhaps even a tribunal to deal with issues that cannot be resolved within the ministry. That would really resolve a lot of matters, and that would also create another situation where the JPN will have to give a reason, right? So perhaps moving forward, let's work together. This is a great start, or this is another step towards reform. And thank you very much, ladies and gentlemen. We can adjourn for lunch.
Jutaan terima kasih diucapkan kepada barisan panelis dan moderator yang telah berkongsi ilmu dan pendapat bersama-sama kita sebentar tadi. Semoga segala yang telah disampaikan dapat dimanfaatkan semaksimum mungkin ke arah Malaysia yang lebih aman dan harmoni pada masa akan datang. Bagi pihak urus setia, kami memohon maaf atas sebarang kesulitan yang timbul semasa sesi panel sebentar tadi. Majlis juga merakamkan setinggi-tinggi penghargaan dan jutaan terima kasih kerana sudi bersama-sama kami pada hari ini, baik secara fizikal maupun para hadirin yang setia bersama di aplikasi Zoom. Ada wujud kekurangan atau terpit sebarang keterlanjuran, sepanjang majlis saya kendalikan, ampun dan maaf saya hulurkan. Sampai jumpa lagi dalam majlis Yang seterusnya, sebelum pulang, hadirin yang berada di sini dijemput untuk menikmati juadah makan tengah hari di restoran Serena di tingkat L. Tiket parking boleh disahkan di luar dewan dengan kadar rata RM14 sahaja dan laporan fizikal boleh diperoleh di bahagian luar dewan sebentar lagi. Sekian, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi taala wabarakatuh. Selamat tengah hari. Bonjour. Ada pengumuman, kita jumpa satu telefon bimbit. Kalau ada yang kehilangan boleh tuntut di sini. Jenama Huawei.